We have made the amendments along three broad thrusts. Firstly, MOM will establish an administrative penalty regime to enforce administrative infringements to complement our prosecution efforts. We will impose significant administrative financial penalties and administrative actions such as debarment from applying for and renewing work passes. The purpose is to deter employers from exploiting the work pass framework for financial gain. Secondly, to enhance deterrence, MOM will introduce new EFMA contraventions and increase penalties commensurate with potential profits gained from the abuse of the system. Third, to facilitate enforcement against common contraventions and syndicate operations of increasing complexity, MOM will include new presumption clauses and expand our investigatory powers. Now, to further enhance deterrence, we will increase maximum penalties for EFMA contraventions. The penalties have been benchmarked against contraventions of similar nature in the Immigration Act and the Penal Code. They have also been calibrated to ensure that more egregious offences attract higher penalties. Severe offences such as the illegal employment of foreign workers will be subject to harsh penalties, including a minimum fine of $5,000 up to a maximum fine of $30,000 and or a maximum imprisonment term of 12 months for first-time offenders. This will also allow the courts to take into account any costs avoided by the employer, including medical and work injury compensation, insurance premiums, security deposits, and levy payments. Administrative infringements such as a failure to terminate the employment of a foreign worker after receiving notification of the controller's revocation of the worker's work pass will be subject to a $10,000 administrative financial penalty. So it is very critical that employers are able to meet the criteria for hiring S-Pass and employment pass holders, not only when they apply for the pass, but through the validity of the work pass. At present, there are no explicit restrictions on the reduction of salary after an S-Pass or employment pass holder has secured a work pass here. An errant employer, and they exist, would circumvent the salary criteria of our S and employment passes by declaring higher salaries to secure these passes and then sharply reduce the salaries thereafter, after the passes have been issued. To close this loophole, we will require all employers who wish to reduce the salaries of his S-Pass and employment pass holders to submit a request for reassessment of their work pass eligibility. This will not prevent employers from reducing the salaries of the foreign workers for legitimate reasons. But all they have to do now is to submit the lower salaries for reassessment of the eligibility of a work pass, and we will consider that. If they are not eligible for their current work passes, the employer may consider downgrading to another work pass that carries more restrictions, or try harder to recruit a Singaporean. This new requirement will be elaborated in the EFM regulations. This requirement will make it harder for current employers to abuse the work pass framework and help protect job and wage growth opportunities for Singaporeans. The failure to comply with this regulatory condition will be subject to a maximum administrative financial penalty of $10,000.